Welcome to Trust and Estate Clarity with Dada Law Office.
Welcome to Trust and Estate Clarity with Dada Law Office and attorney Codi Dada, founder of the Codi M Dada Law Offices in Novato, California. Recognized as one of the top 10 best law firms in California, Codi focuses exclusively on estate planning, trust, and probate administration. I'm Lisa Mosbey, your host, and today we're focusing on what actually happens in the days and weeks after someone passes away with a living trust in place and what a trust is expected to do right away. Welcome, Codi. Thank you so much for joining me again today.
Hi, Lisa. Thank you. Thank you. It's a pleasure to be here.
You know, Codi, when someone passes away and there's a living trust in place, how does the successor trustee typically find out they're responsible for handling everything?
That's a great question. So typically, the person who set up the trust, which they're called the trustors or the settlors, right? They tell those people in advance. They should tell them and say, I've named you in my trust, and they should give them a copy of the trust so they don't have to frantically go through and try to find these documents. It's very important that they are aware that they're the trustees and that they know where to find the documents. So what we do for all our clients is after all the final documents are completed is we create a digital backup copy so that they can easily email it to their loved ones and then those people that they choose to have a copy. So when those documents are needed, there's not a frantic search for your blue binder, the estate planning binder. And if those documents are lost, which I've seen happen, people move, they put them in boxes, they get stored. If they can't find those documents, it's as though they never existed. And therefore, we still have to go through probate. So another way is that they're notified, the people that are listed as the successor trustees are notified by the loved ones after a person becomes incapacitated or it passes. Then someone usually gives them a call and it says, hey, you are named in this document. And now they're kind of surprised and they're confused. They don't know what to do. And they need to go and counsel with someone to give them some guidance on what needs to occur on the next steps. But that's typically how people find out.
And in those first few days, what tends to feel most overwhelming for someone stepping into that role for the first time?
So they have what's called a fiduciary duty, which is the highest standard by law. And the law requires them to do things a certain way. And as a normal person that doesn't deal with trust administration on a daily basis, they're completely lost on what they need to do. So the first thing that they need to do is identify all the assets, really. That's the most important thing. And to safeguard everything, it's called marshaling the assets. And so they have to identify all the bank accounts. They have to identify any real estate, retirement accounts, investment accounts, and make a list of what assets are part of the estate.
And then, Codi, are there other steps? Let's walk through an example of how this process starts, which compiling the assets, and then how does that unfold for the trustee who's never done this before?
Right. It's very confusing for people who've never done this before. But the first step is to get acknowledged as a trustee. So after they identify all the assets, then they have to go to each of the financial institutions and get acknowledged as a successor trustee. So that either requires bringing in a doctor's note that says that the settlor, the person who set up the trust, has become incapacitated, or a death certificate. And at that point, the banks and the other third parties will acknowledge that person as the successor trustee and give them access to those bank accounts and the different assets. And then the law requires the trustees to give notice to all the beneficiaries. So within a relatively short time after someone passes, we have to give out what's called a notice by trustee. And that requires the trustee to send out this formal notice that tells all the beneficiaries that they are the trustees and how they are contacted, and give them a copy of the trust. Okay. And then once they give them the notice, they have a duty to file the final taxes, pay all the final bills, maintain any mortgages, insurance policies, collect any proceeds from any life insurance policies, gain access to retirement accounts, and then give notice to the people that are either named as beneficiaries on retirement accounts, life insurance, or obtain access to those proceeds and put them into a trust account, put them into a unified estate account that holds all the assets before any distributions go out. And then once all the assets are identified, all the bills are paid, they have to provide an accounting to the beneficiaries. By law, every year the trustee has to give an accounting to all the beneficiaries, which are the people that are getting the stuff from the trust, right? The assets from the trust. And they have to show how much money they started with, where the money was distributed, what money came in, what money went out, and how much is left over. And then they have to report that to all the beneficiaries and gain permission, basically. Before anything goes out, we want to make sure that everyone agrees to what's going on, because the problems arise is if you distribute the assets too early and then one of the beneficiaries later objects or has questions or requires more clarification, then that's going to require additional fees, additional either tax preparation fees or attorney um, counseling fees or whatever's going on. So once the money gets distributed to the beneficiaries, it's hard to get it back if you later find that everything wasn't settled. So the process is gather the assets, pay all the bills, file all the taxes, give notice, and gain everyone's consent. And that's through a notice of proposed action. And the trustee sends out what's called a notice of proposed action, which explains to everyone exactly what they're going to do and how they're going to do it, whether they're going to get paid, if there's going to be a reserve for future expenses, next year's taxes. And that way, once that goes out to the beneficiaries, everyone is on board with the game plan. And if they have any objections, it gives them an opportunity to voice their objections before money goes out, before real estate is sold, before bank accounts are closed. And then if there are objections, we can resolve them and talk through it and make accommodations before those objections become into conflicts and eventually litigation. And the process is designed so that it protects the trustee. So once all the beneficiaries consent to the notice of proposed action, by law, they can't come back later and challenge what the trustee has done. So it avoids the potential of people changing their minds or forgetting what they agreed to, or just trying to game the system and trying to get more money than they were left behind by making problems so that they get a settlement. So it's a formal process. It allows everyone to understand what's going on, and it protects the trustee from further hassles and conflict. Once everyone signs the notice of proposed action, then the trustee, by law, can do what they said they were going to do in that proposal without worrying about getting in trouble. It's a first step. That's really the way to go. And a lot of people don't realize this. And so they start too quickly. They want to distribute things too soon. And they're getting influenced by the beneficiaries' inquiries. And, it just becomes a stressful mess for them. So it's important to just slow down and take things one step at a time.
Codi, this is very overwhelming. Just me sitting here listening, and I've been through this process more than one time. So I have an understanding, but as you're explaining it, it feels so overwhelming. And I can imagine what our listeners are feeling at the moment listening to this. Identifying and securing trust assets and bank accounts and real estate and putting it all into one secure location. Do you, as their attorney for the trust holder, walk through this process with the trustees? Are they in partnership with you, or are you standing there side by side with them going through this? Is that all part of the trust setup process to make sure that there is a guiding hand through this process?
Yes, for sure, for sure. We understand that people don't know what to do. And why would they? They don't teach us this in school, right? So we do this on a day in, day out basis. We see the problems that arise and we see how banks react and the problems that escrow companies create. And we know what it takes to make sure things work out smoothly. And so what we do is we hold the client's hand and we take it one step at a time. Here I'm trying to give you a, full explanation, but in reality,
Yeah.
what we do is we break it down into bite-sized stages, and we'll coach the client as circumstances arise based on that person's specific circumstances. So not all facts are going to be relevant in every trust administration. But once we learn the assets involved and the family dynamics and what the trust says, is we give them a game plan, a written game plan that they can follow, and we coach them through as we progress through the different phases. And as things come up, we allow them to contact us whenever they want, and we will get to them immediately with answers, resources, create documents, and guide them no matter what's going on at the time.
So we're not alone during one of the most difficult times in a person's life.
Yeah, that's our job. We don't just create a bunch of documents and send you on your way. We're partners with the client. We are kind of there at all times when they need us. So we allow them to contact us whenever they want. They can email us, they can text us, they can call us. We're very accessible because we understand it's impossible to predict every little detail from the get-go. Things come up, and what they new in the beginning may change as the process develops and new assets are identified, new situations arise, questions come up with the beneficiaries. There's numerous things that come up. So it's really not practical to say, here's a cookie cutter, one size fits all thing, especially for trust administration, because there's so many variables. But that's our role. That's why we've dedicated our practice to this exclusive area so we can get really good at something and provide a great value for our clients by having the answers available from our real world experience.
Codi, one of the other kind of aha moments I'm having sitting on this side of the microphone is the mistakes, like fear of making a mistake. Like we said, this is one of the most stressful times that we go through when we are saying goodbye to our loved ones and we have to manage their estate. What happens if certain assets weren't properly placed in the trust before a person passes away? How do you help somebody walk through that at this point after the person has passed?
Right. Yeah, I can understand that. It's overwhelming for people. They really don't know what to do. The major mistakes is moving too quickly and wanting to oblige the beneficiaries' wishes. The beneficiaries are gonna usually they come in and they're eager to get their share of the trust. They want their inheritance, but they don't realize that the trustee has many obligations, filing taxes, settling the estate, all those different things. The trustee has plenty of time. The law knows that this isn't a quick process, so that the trustee is not forced to act quickly. They have as much time as they need as long as they're working diligently. Okay? But the main problems that we see is number one, trying to distribute money too soon and then finding out later that there was other bills that needed to get paid. And now you're trying to chase people and trying to get money back. And we know how hard that is getting money back out of people, right? So the thing is if the assets aren't titled in the trust, then there's certain mechanisms that allow us to bring them into the trust. There's depending on the size of the asset. So there's what's called a small estate affidavit, which means that if the assets that were not part of the trust are less than 208,850, then we can create this declaration for the client to bring to the financial institution, which the law supports and requires that financial institution to turn over the assets to the trustee. Okay, so that's one way to do it. Other ways are by showing clear and convincing evidence that the person who created the trust intended for that asset to be part of the trust. That's called, oftentimes, it's called a Heggstad petition. And what it does is that if there is certain language in the trust and there's certain documents within the estate plan that show that you wanted all your assets to be part of the trust, then we can go to court and show the judge that you intended for this asset to be part of the trust, even though it wasn't titled in the trust. And then we can get a court order that allows us to transfer the property directly from the financial company to the trust. Um, and so that's something we don't want to rely on because we still have to go to court, but it's a lot better than the full probate process. Another mechanism is with real estate. As of April of 2025, if your real estate is less than 750,000, we can do a small estate affidavit to get an order to transfer your real estate to the trust. Again, it requires court process, but it's a limited process and it doesn't require the extensive year-long probate process. So those are different ways that we often kind of fill in the gaps when people don't properly title assets. Another important aspect is having your assets listed in the schedule of assets, which a lot of people don't do. But what the schedule of assets does is, number one, it creates an inventory list so that your loved ones know where your bank accounts are located and what assets you own. Because nowadays, with the prevalent frauds that occur with the financial institutions, even if a person did have a bank account at a certain company, that bank won't admit it. If we called and we said, hey, mom, we believe mom has an account at your bank, they will say, we can't say yes or no because we're not going to set someone up to get frauded. So it makes it very difficult for your loved ones to manage your assets if you're unable to communicate because you're incapacitated or you pass away. So the schedule of assets, number one, creates an inventory list for those people to go and understand where they need to deal with and what companies they need to contact. And then also, number two, it shows your intentions. It shows clear and convincing evidence that you intended to put that asset in the trust because it's on the schedule of assets and it has to be signed. I've seen a lot of other attorneys that don't understand how this works, and they just put this generic list together, but they never have the client sign it. So when we go to use it for that purpose, the judge doesn't believe us because we could have made that document up a week before, that there's no evidence that this was you that created this and when it was created. So that's another way that we fill in the gaps, so to speak, and we compensate for people's imperfections.
Codi, I want to thank you for taking us through all of the finer details and some of the nuances that are involved in estate planning. Knowing that you're there to walk through this process with your client and with their loved ones after their passing, and knowing that when mistakes happen, there are solutions waiting in the wings. Not always easy, but they are available. And when you're working with a professional, somebody who focuses and specializes on trust and estate planning, that they will be taken care of. So thank you so much for your time today. I appreciate it.
My pleasure. Thank you, Lisa.
And folks, thank you for joining us for the Trust and Estate Clarity podcast with Dada Law Offices and attorney Codi Dada. Please take a moment to subscribe, like, and share this episode if you know someone who may need to hear about it today. For more resources or to start your own plan, please visit dadalaw.com. Thank you so much for tuning in. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.